Imagine waking up tomorrow and discovering that the legal foundation of your country, like the actual deed to the land under your feet, the basis of your entire property system, is built on just a complete documented legal fiction.
It's a pretty wild thought, honestly.
Right. Well, welcome to the Deep Dive. Today, we're taking this huge stack of research, historical transcripts, and legal analyses that you sent us, and we are looking at really the most profound what-if in modern Australian history.
Yeah, it's a fascinating alternate history framework to dig into.
It really is. So we're going back to 1992. The High Court has just handed down the Mabo Decision, which was this absolute turning point that throws out Terra Nullius, the legal doctrine that the continent just belonged to no one before the British arrived. And it recognizes native title. It fundamentally changes the nation. But we're exploring a specific scenario today. What if the High Court had ruled the other way?
And it is a genuinely unsettling counterfactual to map out when you really get into it.
I bet.
Because when you analyze the legal mechanics of that era, you realize just how incredibly fragile that historical pivot actually was. I mean, the real timeline gave us a 6-1 decision in favor of Eddie Mabo and the Miriam people.
Right, acknowledging that pre-colonial land interests survived British sovereignty.
Exactly. But to build out this alternate reality, the sources ask us to look really closely at that one dissenting judge.
Justice Dawson, right? He was the lone holdout on the bench. And his argument, from what I read, wasn't just a minor disagreement about the details. It was a fundamental rejection of the entire premise.
It was, yeah. Dawson's logic was deeply rooted in this very traditional colonial jurisprudence. He basically argued that when the British Crown asserted sovereignty in 1788, and then later when Queensland annexed the Murray Islands in 1879, those actions just automatically vested full, absolute beneficial ownership of all the land in the Crown.
Wow. So just instantly.
Instantly. In his view, the Crown's mere intention to treat the land as its own just totally extinguished any pre-existing Indigenous rights. There was no need for explicit confiscation. The act of planting the flag was, legally speaking, the absolute erasure of prior ownership.
Okay, let's unpack this. So in our alternate timeline, Dawson somehow manages to convince the majority of the bench, right? His dissent becomes the supreme law of the land. If that happens, where does that actually leave the Australian legal system?
Well, it leaves the system firmly trapped in the logic of a previous landmark failure, which was the 1971 Gove land rights case, often called Milirrupum v. Nabalco.
Oh, right.
Yeah. Without Mabo, the Gove decision just remains the ultimate precedent. And the Gove case is this fascinating, almost tragic study in judicial cognitive dissonance.
I've always found the Gove ruling just so bizarre. I mean, the judge in that case, Justice Blackburn, he literally looked at the evidence, fully acknowledged that Indigenous people lived on the land for tens of thousands of years, and even admitted they had a highly intricate system of law. But then he essentially ruled that legally, their ownership just didn't exist.
Yeah, the sources suggest we probably shouldn't call it bizarre so much as a really strict, rigid application of British common law. Blackburn concluded that the Indigenous relationship to the land was, quote, religious, not proprietary.
Wait, so because it was spiritual, it didn't count as property?
Basically, yeah. Under British law at the time, for something to be considered property, it typically had to be alienable, meaning you could sell it, trade it, or physically exclude others from it for economic gain.
Ah, I see.
And because Indigenous law treats land as an inalienable spiritual responsibility, a stewardship, Blackburn's framework just simply couldn't compute it as property.
I really struggle to see how a modern society sustains that kind of contradiction, though. I mean, if we acknowledge you built the infrastructure, maintained the land, and governed it for generations, but we refuse to recognize your title because you don't intend to sell it, isn't that like acknowledging a tenant built an entire apartment complex but classifying them as a trespasser just because they don't charge themselves rent?
That analogy definitely highlights the absurdity of it, but I frame it slightly differently based on the legal texts. It wasn't really about rent. It was about the fundamental mechanism of state power itself.
Okay, how so?
Well, if Dawson's logic holds, the foundational document of Australian land law remains the 1835 proclamation by Governor Richard Bourke. And Bourke explicitly declared that anyone occupying land without government authority was a trespasser.
Wow.
Yeah. This is what legal scholars call decolonization failure. Without Mabo, colonial structures aren't just like historical background noise. They are actively operating legal tools. Indigenous people living traditional lifestyles on their ancestral lands would literally be criminalized as trespassers under modern law.
But, I mean, if the judicial system entrenches a failure that massive where citizens are legally trespassers on their own estates, doesn't the democratically elected parliament eventually step in?
You would think so, right?
Yeah, like if the courts fail to fix a glaring structural flaw, the legislature usually acts just to avoid total social collapse. Why wouldn't they just pass a law to fix it?
You might assume that, but the historical evidence from the 1980s strongly indicates Parliament was just completely paralyzed. Without the High Court dropping the Mabo decision like a bomb into the middle of the political landscape, the legislative branch simply lacked the political will to act.
Wait, I need you to prove that to me.
Yeah.
Because when the Hawke government came into power in 1983, they ran on a platform promising uniform national land rights legislation, didn't they? There was massive public momentum.
There was.
So why assume that momentum just vanishes without Mabo?
Because it did vanish, even in our real timeline, long before Mabo was decided.
Oh, really?
Yeah. By 1986, Prime Minister Bob Hawke completely retreated from that national agenda. And the mechanics of that retreat are crucial for this alternate timeline. It wasn't a loss of moral conviction, it was raw political calculus.
Let me guess. Industry pushback.
Exactly. The mining lobby, particularly over in Western Australia, mounted this multi-million-dollar campaign against land rights. They framed it as a massive threat to suburban backyards and, overall economic stability.
What?
Western Australia's premier at the time, Brian Burke, made it crystal clear to the federal government that pushing national land rights would cost the Labour Party vital Western Australian seats, which could potentially flip the entire federal government.
So what does this all mean? The political sting was just too severe. A federal leader isn't going to sacrifice their entire government for a land rights bill if the states are actively threatening a revolt.
Exactly. So if we extrapolate that into a no-Mabo reality, the absolute high watermark for legislative reform would have been the Hawke government's abandoned 1985 preferred national land rights model.
And what did that model actually look like on the ground? Was it any good?
It was incredibly weak. It offered what was called statutory title.
Statutory title.
Yeah, unlike native title, which acknowledges an inherent pre-existing right, statutory title is essentially just a grant from the government. And it's a grant that can be easily revoked.
Oh, wow. So it's not real ownership.
Not really. And crucially, this model required absolutely no Aboriginal consent for mining operations on that land, and it explicitly banned any claims over pastoral leases or stock routes. It gave the illusion of land return while carefully preserving the absolute economic supremacy of the resource sector.
The irony there is staggering. You constantly hear modern political rhetoric complaining about judicial activism. The idea that judges should just interpret the law and leave social change to elected officials.
Right, you hear that all the time.
But looking at the mechanics of the 1980s and the sources, the legislature was totally captured by industry lobbying. Without the High Court blowing up the status quo, the politicians were structurally incapable of delivering reform.
They were completely locked in a political dead end. I mean, when Paul Keating delivered his famous 1993 address to the nation, he explicitly noted that the court's decision forced the country to face a challenge it had previously just ignored. If that legal shockwave never happens, the state simply maintains the paralysis.
Which sets up a pretty terrifying domestic scenario. If the legal door is bolted shut by the High Court reaffirming Terra Nullius, and the political door is welded shut by a paralyzed parliament handing out toothless statutory titles, the Indigenous population is left with zero institutional avenues.
Exactly.
If you systematically deny an entire population any legal existence or path to recourse, they aren't going to just quietly fade away. They're going to step outside the system.
That is the inevitable consequence, and it represents a massive shift in the projected social landscape. Mabo really functioned as a critical pressure release valve. It took decades of raw, escalating Indigenous activism and sort of channeled it into a formal, structured, highly bureaucratic legal process.
It gave people a reason to actually engage with the state.
Precisely. Without that, the pursuit of reconciliation is just abandoned entirely. The movement pivots toward total sovereignty and separatism.
The research you shared dives deep into the Aboriginal Provisional Government, the APG. Michael Mansell founded it in 1990. In the real timeline, the APG was often viewed by the mainstream as a radical fringe group. But in a reality where the High Court actively criminalizes traditional land ownership, The APG's ideology basically becomes the baseline moderate response.
Yeah, because the strategy of seeking equal rights within the Australian system would have been demonstrably proven to be a complete failure.
Right.
The APG's strategies weren't just rhetorical either, they were highly structured. They demanded an independent Indigenous nation-state with its own parliament, legal system, and borders. And the primary mechanism for achieving this was domestic ungovernability.
Wait, domestic ungovernability, what does that actually look like in practice? Are we talking about a civil war?
Not necessarily armed conflict, no, but systematic civic decoupling. It means rejecting state-funded services as instruments of colonial assimilation.
Okay, so building their own systems.
Exactly. It means establishing parallel infrastructure, running their own schools, health clinics, and governance bodies, while entirely refusing to recognize the jurisdiction of the Australian state, its police, or its courts. It is literally the creation of a state within a state designed to make the daily administration of the country practically impossible.
Here's where it gets really interesting, though. They didn't just plan to disrupt things domestically. They were actively building an international strategy. The sources point out that in 1988, Michael Mansell actually traveled to Libya to get Aboriginal passports formally recognized by Muammar Gaddafi.
He did.
Now, today, people might look at that as just a controversial historical footnote, but what was the actual strategic goal there?
The goal was diplomatic guerrilla warfare. By engaging with an international pariah state like Libya, the APG was basically bypassing the Australian federal government entirely and acting as a sovereign entity on the world stage.
Wow. So Gaddafi offering support wasn't really about Libya caring about Australia.
No, Gaddafi offering support and recognition wasn't about Libyan interests at all. It was just about embarrassing the Western Bloc. And in a no-Mabo world, the analysis projects this wouldn't be a one-off stunt. It would escalate into a sustained strategy of seeking alliances with nations hostile to the West purely to leverage international geopolitical friction against the Australian government.
That level of domestic ungovernability and diplomatic warfare leads us to a massive economic paradox. The mining and pastoral industries fought Mabo relentlessly, right?
Oh, absolutely.
They spent millions arguing that recognizing native title would destroy the certainty of land ownership and just wreck the resource economy.
Yeah.
But if we follow the mechanics of this alternate timeline, a no-Mabo world is actually infinitely more volatile for capital investment.
That is the great irony of the resource sector's lobbying efforts. If we connect this to the bigger picture, capital markets despise unpredictability above all else.
Right. Investors hate risk.
Exactly. In reality, the Mabo Decision forced the creation of the Native Title Act of 1993. Now, that act is incredibly complex, heavily bureaucratic, and it's criticized by both Indigenous groups and mining companies. But what it did was provide a structured, predictable legal framework. It established the right to negotiate and mechanisms like Indigenous land use agreements, or ILUAs.
Let's break down how an ILUA actually works as an economic tool. Because it's not just a gesture of goodwill. It's essentially a risk management mechanism.
It's pure risk management. An ILUA brings the traditional owners and the corporation to the table to agree on land use, environmental protections, and financial compensation long before the drills ever hit the dirt.
Okay.
Once it's signed, it is a legally binding contract that effectively immunizes the corporation from future legal challenges or operational disruptions. It literally buys the company certainty.
So without Mabo, the ILUA framework just doesn't exist. Companies are granted leases by the government, but the Indigenous communities living on that land have zero legal avenue to object or negotiate. If the law won't hear them, their only remaining leverage is physical.
Yes, the primary tool becomes the blockade. The sources suggest we can look at the 1998 Jabiluka uranium mine blockade as a template. That saw thousands of protesters, massive logistical nightmares, and just enormous financial losses for the operating company.
Right.
In a no-Mabo world, Jabiluka isn't an isolated, high-profile event. It is the daily, standard operating procedure for resource extraction across the entire continent.
And think about what that does to a mining company's bottom line. Instead of sitting in a boardroom with lawyers hashing out a compensation agreement, companies are relying on state police forces, riot gear, and physical force just to access their leases. But if mining companies are seen globally as looters rather than partners, how does that affect their international funding?
Well, institutional investors in London, New York, or Tokyo, they wouldn't look at Australian mining companies in this timeline and see safe, regulated bets. They would see unmanageable sovereign risk.
Wow, yeah.
Furthermore, they see an ESG nightmare. Environmental, social, and governance criteria govern trillions of dollars in global capital today. If the Australian resource sector is entirely reliant on the forced physical dispossession of Indigenous people, it heavily mirrors the dynamic of conflict minerals.
People would just pull their money out.
Exactly. You would see massive, coordinated global divestment campaigns. Capital would aggressively flee the country because the reputational risk of holding Australian assets would just be too high for major international funds to justify to their shareholders.
Which brings the economic crisis directly into the realm of foreign policy and international law. Because it's not just corporate reputations taking a hit, it's the entire nation's standing. Through the 1990s, the international community was shifting, You had nations like Canada and New Zealand actively recognizing Indigenous treaties and rights. They were moving toward legal modernization.
Right. Meanwhile, Australia would be stubbornly clinging to Terra Nullius. It would become what legal historians in the text term an intellectual isolationist in the common law world. And that isolation wouldn't just be theoretical, it actively triggers mechanisms within the United Nations, specifically the UN Committee on the Elimination of Racial Discrimination, or CERD.
We know CERD has criticized Australia in the real timeline regarding mandatory sentencing and intervention policies. But criticism is just words on paper. How does that escalate to actual consequences in a scenario where Terra Nullius is legally upheld?
It escalates because the legal violation becomes structural rather than incidental. Gay McDougall, a rapporteur for the committee, has analyzed Australian land practices through the lens of international covenants.
Okay.
If the High Court had reaffirmed Terra Nullius in 1992, the Australian government would be actively enforcing a property system based purely on racial exclusion. There is no legal defense against that under the UN conventions Australia itself signed. The situation would utilize the boomerang model of international relations.
The boomerang model.
Yeah.
Meaning domestic activists realize they can't get anywhere with their own government, so they throw their appeals outward to the international community, which then brings pressure back down on the state.
Precisely. Indigenous activists would bypass Canberra entirely, taking their case straight to the UN, human rights tribunals, and international media. This would inevitably transition CERD's response from mere written criticism to formal sanctions. In the eyes of international law, the sources say Australia would be grouped alongside apartheid-era South Africa.
Wait, really? Apartheid South Africa?
Yeah. The legal parallels of a state utilizing its judicial system to disenfranchise an original population based on race are legally identical.
If you're categorized alongside apartheid South Africa in the 1990s, you become the target of widespread economic and cultural boycotts. The analysis here points directly to the 2000 Sydney Olympics. There's a very real geopolitical mechanism where hosting that event becomes completely impossible.
The International Olympic Committee would face unmanageable pressure. Participating nations would threaten boycotts, international media would focus exclusively on the civil rights abuses, and the domestic ungovernability we discussed earlier would guarantee mass protests disrupting the infrastructure of the games themselves. The Olympics would either be canceled or relocated entirely.
And beneath all of this geopolitical drama, there is just the brutal, localized human cost. I mean, we aren't just talking about abstract legal theories. The Human Development Index data in the sources outlines exactly what happens to a marginalized population denied an economic base. Without the structural recognition of land, which provides at least some baseline for economic autonomy, the health and wealth gap for Indigenous Australians doesn't just stagnate.
No, it cascades into a severe, escalating humanitarian crisis. By the time we reached 2009, when Australia initially refused to sign the UN Declaration on the Rights of Indigenous Peoples, the context completely changes.
Because in our real timeline, that refusal was highly controversial, but eventually reversed.
Right. But in a no-Mabo timeline, amidst a widening mortality gap and a state actively deploying police to enforce Terra Nullius on mining sites, that UN refusal isn't just diplomatic stubbornness, it is an aggressive, defiant doubling down on a colonial fiction against the consensus of the entire global community.
It is genuinely staggering to trace the mechanics of this alternate reality. We started by asking a simple question about a single court case. But tracing the cause and effect shows us that the Mabo decision wasn't just a legal correction for Eddie Mabo and the Miriam people. It was a structural pivot that literally saved the Australian state from itself. By forcing the legal framework to align with historical reality, it prevented the country from collapsing into domestic insurgency, unmanageable sovereign risk, and total international isolation.
It forced a legal reckoning, absolutely, but there is a final concept drawn from the analysis, specifically from the work of Indigenous legal scholar Larissa Behrendt, that demands our attention here. Behrendt argues that while the High Court successfully overturned the legal fiction of Terra Nullius, we must confront the persistence of a psychological Terra Nullius within the broader settler society.
Psychological Terra Nullius, meaning the legal doctrine is gone, but the cultural operating system hasn't actually been updated.
Exactly. It's a mindset that continues to view Indigenous people, their knowledge, and their rights as sort of peripheral to the real business of the nation. It represents a societal struggle to fully integrate the reality of colonial dispossession into the core identity of the state, treating Indigenous rights as an annoying bureaucratic hurdle rather than foundational law.
Which really leaves you wondering, if that psychological Terra Nullius still fundamentally influences how policy is made and how resources are extracted today, what other massive legal fictions are we turning a blind eye to right now? What current accepted norms of property and sovereignty will a high court 50 years from now look back on and realize were built entirely on a lie?